provisions of yeah. Now we have been discussing. We have discussed the provisions of may presume, shall presume, huh? And today's topic will be conclusive proof. So you learned that here in the may presume section 4 के अंदर you learned section 86 to 88, isn't it? When the court can presume that the document can be taken under record, presumption that the document can be taken under record, isn't it? Got it? Hello, can you hear me?
Yes, sir.
Yes,
Yeah,
sir.
the examples of may presume we dealt under section 86 to 88. When you just briefly recapitulate your memory, don't forget them. This is a very important section 80, section 86. Section 86 dealt with presumption as to certified copies of foreign judicial record. I will give it today one of the two judgments of the Supreme Court dealing with when a decree was passed by an American court uh, under the Hindu Marriage Act, and the same was not enforced in India. Well, because it was the contention raised was that here the court which passed the decree in USA in Louisiana was not a competent court within the meaning of section 13 of the Code of Civil Procedure, and the copy of the judgment, whether the copy of the judgment which was furnished to the party from the foreign court, uh, how it can be produced before the Indian court, because the wife subsequently files a bigamy proceedings under the Indian Penal Code. That's a very interesting judgment. I will discuss with it here. So before I discuss with so section 4 can the may presume, you have to remember section 86 to 88 and section 90, that is a 30 years old document. Then 114 may the code, the presumption, natural presumption. Then in the shall presume may we discuss the provisions of section 79, 80, 81, 81A, 82, 83, 84, 85, 85A, 85B, 85C. That is all dealing with some section 79 onwards. If you see that here, section 79 onwards, um, presumption as to genuineness of certified copies, presumption as to protection, where the and presumption as to gazettes, electronic forms, presumption as to the records of English court, presumption as to the documents and maps of the authority of India. These are all the court shall presume that these are genuine documents. The court may presume. Of course, in both the examples under section 4, we learned that the presumptions which may be drawn are rebuttable presumption. Mean the court will give an opportunity to the party denying. A party say that your lordship may not be pleased to draw the presumption. It is a presumption is merely a prima facie finding. A prima facie finding by the court. Yes, the document can be taken on record. It is coming from proper custody. But if the other side want to challenge it here, it's a fraudulent document, it's a forged document. You have the right to lead evidence, nothing to worry about it. So these are the illustrations where in both the cases of may presume and shall presume, you have opportunity to lead evidence in rebuttal. Whereas in the cases of conclusive proof, conclusive proof means, see, please turn to section 4 mein aa jaiye. That is the last limb of section 4. When one fact is declared by this act to be conclusive proof of another. Conclusive proof means a clinching evidence, an evidence which is totally satisfactory to the court and believable by the court, and no evidence can be adduced to normally to dislodge it. See, whenever it is directed, when the fact is declared by this act to be conclusive proof of another, the court shall, on proof of one fact, regard the other proved and shall not allow evidence to be given for the purpose of disproving it. See, in the earlier two cases in may presume, shall presume, parties had the opportunity to lead evidence to disprove it. But whereas in the case of conclusive proof, the section says that here, parties shall not be entitled to disprove it. You will not be allowed to disprove it. Okay, this is very tricky situation. That means it is a gospel truth. A document cannot be challenged. And evidence, there in the Evidence Act, there are only three examples. There are only three sections which dealing with conclusive proof. Number one, section 41, we'll go into it. Then 112 and 113. We'll now deal one by one. Now let us come to the what section 41 says. Section 41, please open your section 41. It says relevancy of certain documents, relevancy of certain judgments in probate, etc. of jurisdiction. A final judgment and order or decree of a competent court, underline the word competent court, in the exercise of probate, number one. Number two, matrimonial. Number three, admiralty. Number three, insolvency jurisdiction, which confers upon or takes away from any person any legal character, or which declares any person to be entitled to such character, to be entitled to any specific thing, not as against any specific person, but absolutely is relevant when the existence of such a legal character or title of such person is relevant. Such document, order and decree is a conclusive proof. Kindly underline this here. So I will make you understand the import of this section. This is a very delicate section. This section cannot be read alone. This has to be read along with the provisions of section 13 and 14 of the Code of Civil Procedure. I will tell you why. Let us see. Then the second, the second paragraph says that here, that the legal character which it confers accrued at the time when such judgment and order decree came into operation, then that any legal character which is declared any such person to be entitled to accrue to a person at the time such judgment and order or decree has accrued to the person, that the legal character which takes away from such person ceases at the time from which judgment, order, the decree that it has ceased to decree. And anything which is declared by the person to be so entitled was the property of the person at the time from the such judgment, order or decree declared that has been so and so. So in order to invoke section 41, what is important? It see that here. Now you must have learned in your first, second year, judgments in rem, judgment in personam. You understand this? समझ में आ रहा है अभी? Are you in a position to recapitulate? Judgments in rem, judgment in personam. A judgment in rem is which is a judgment given by the court which is binding on the entire world. Whereas a judgment in personam is a judgment between the two parties, to the litigating parties, which is only binding upon them, not binding upon third parties. Now, section 41 postulates a situation that the final judgment and decree passed by the four branches of the law, namely a probate court, a matrimonial court, admiralty court, insolvency court, by a competent court, they have a legal character, and these judgments become a judgment in rem, not only binding upon the parties who are litigating, but binding upon the entire world. Now I'll give you illustration. Now take for example here, now a decree of a competent court, number one, probate. Now under the Indian Succession Act, you will learn that here a probate petition, a will which is executed in your favor, is not a valid document unless it is probated, isn't it? The will required to be probated under section 263 of the Succession Act. And jurisdiction is given to the district court to grant the probate. And in the city of Bombay, the High Court of Judicature at Bombay, by virtue of its latest patent, is a district court. In the city of Bombay, the High Court original site exercises jurisdiction to issue a probate. So, suppose a will has been lodged of your grandfather in your favor, you filed it, the matter was contested by your brothers and uncles, sibling. Ultimately, the court says, yes, the will is a proper document. The will is a proper. Now, in order to prove a will, you know the provisions of section 63C of the Indian Evidence Act. Please, can you open section 63C? Sorry, Indian Succession Act. That खोल दीजिए. Because this section 44 should be read along with the provisions of section 63C of the Indian Succession Act. That खोलेंगे आप? I will just take it by act. See, section 63 says, execution of unprivileged will, then requirement C, subclause C, the will shall be attested by two or more witnesses, each of whom has seen the testator sign or affix his mark or will, or has seen some other person sign the will in the presence and the direction of the testator, or has received from the testator or a personal acknowledgement, or is signing the make a signature of such person, and each of the witnesses shall sign sign the will in the presence of the testator, but it shall not be necessary that more than witness present at the same time, and no particular form of attestation shall be necessary. So this tell you what are the fundamental requirement of a will, and you have to adhere to it. Under the Evidence Act, now this section 63 subclause 3 of the evidence of the Indian Succession Act should be read along with the provisions of open plea section 68. खोलिए जरा. Yeah. Section 68, 69 and 70 are three relevant sections for proving the execution of a document, especially here the will. Now kindly see that here, section 68 of the Evidence Act open कीजिए, because a probate court will take into consideration section 63 subclause C of the Indian Succession Act 1925, as well as the provisions of section 68 of the Indian Evidence Act for the purpose of proving the signature of the will. Now see, if a document is required by law to be attested, now under section 63 you learn the will required to be attested. If a document is required in law to be attested, it shall not be used as evidence until when attesting witness at least has called for the purpose of proving the execution, if there be an attesting witness alive. So provided the witness is alive, because the law says that there must be two witnesses, the both of them need not come, one person sufficient, and subject to the process of the court and capable of giving evidence. Now under the CPC, under provisions of section 16, you read, you know the provision, the court can issue summons to the witnesses to come and depose, and if the witnesses are not beyond 500 kilometers, they cannot be summoned. Now videography can be done, and that was the requirement of order 16. That is out. Then the proviso said, provided that it shall not be necessary to call attesting witness in proof of the execution of a document, not being a will, which has been registered in accordance with the provisions of Indian Registration Act, unless the execution by a person to whom purports to have been executed is specifically done. So, Section 58 of the Registration Act mandates that here, when a document is registered, it is a presumption arises under the Indian Registration Act. So, I'll draw your attention to the Indian Registration Act. Please, this is the right time to see that. The खोलिए Registration Act खोलिए. See Section 58 check करो आप. Particulars to be endorsed on document admitted to registration. On every document admitted for registration, other than the copy of the decree order, copy registration 89 shall be endorsed from the time so and so. Signature is given clause A, signature clause B. Then 59 tells you the signing of the officer, certification of registration 60. So, there is a presumption arises here when a document is registered, it is the court shall take into consideration and presume to be true. Yes. Then come back to the Evidence Act here. So, 68 can be invoked here. Then in case witnesses are not alive, see, when witnesses are not found, Section 69 come into play. If no such attesting witness can be found, if a document purports to have been executed, sorry, Section 69 come into play when attesting witnesses are not found. See that if no such attesting witness can be found, the document purports to have been executed in UK, it must be proved attestation, attesting witnesses in the handwriting and the signature of a person executing the document so and so. Then 70 makes a different case, admission of execution of a party attesting document. The admission of a party to an attested document, execution himself, shall be sufficient to execution. If the defendant is admitting that yes, my grandfather executed the will, I am not disputing, then admitted document need not be proved. That is the provisions of Section 57 padhe aapne of the Evidence Act. Please kindly see that here. Section 57 says facts which Section 58, I'm sorry if I'm not mistaken, facts admitted need not be proved. So if the admission is accepted, Section 70 says that. So the probate court, this is the procedure that will take place before the probate court with regard to the admission of it. So here the judgment, final judgment given by the Bombay High Court or District Court with regard to the validity of the will, execution of the will, is of a legal character, is a judgment in rem unless this will is set aside, either by filing a revocation petition under the Succession Act, or it has been set aside by a competent civil court on the ground that it is a fraudulent document. Otherwise, it attains a legal character under Section 41. It is a conclusive piece of document under Section 41. Read with Section 4 and it's binding upon the entire world. Okay, this is one. Now, the second is it deals of matrimonial proceeding. Now, prior to the family court came into existence, all the district judges, civil courts in Bombay City Civil Court, in district judges, they used to entertain the matrimonial cases. So, a decree granted by the matrimonial court, maybe a family court or a district court, is binding. The marriage of A and B is dissolved. A husband, B takes a decree against the wife. After the death of, that means that the decree is binding, she has not challenged it. After the death of A, she cannot claim that I am the heir under the Hindu Succession Act, I am entitled to his property. The marriage has been annulled. So the brothers of the husband, the brothers, the sisters, the other heirs, mother if any, they can file a suit for declaration that year. The suit filed by the ex-wife is not binding. She cannot claim any legal right of any character. Her marriage has been dissolved with her husband. This is the decree passed by the competent court, namely family court in Mumbai, or a district court in Pune, or a district court in Ahmedabad, or in Delhi, wherever it is. If that judgment is produced, that judgment is a conclusive proof. Please note that it's a conclusive proof. It attains, it is binding on the entire world with regard to the estate of the party, with regard to relationship between the party. Okay, this is one. Now, thirdly, Admiralty. Huh? See, a decree passed by the Admiralty Court. Now, Admiralty suits are filed in the high courts, all high courts in India, Bombay, Calcutta, Madras, under the latest patent or under the Admiralty Act during the British in the Mufassil towns. These are confined to the maritime disputes, whether the all disputes between the sailors and people who are employed in the ship, or you are transported your goods from India to Nairobi, UK, USA by ship, anything damages take place, the ship has not delivered, and you can file a maritime dispute in the city of Bombay. That is called, they are known as Admiralty suits. In the city of Bombay, you know that here there is Admiralty jurisdiction under the latest patent. So, a judgment and decree passed by the Admiralty Court, namely Bombay High Court, Calcutta High Court, Madras High Court, or whichever courts, the civil court normally are excluded. They do not have jurisdiction to entertain Admiralty jurisdiction. So the final judgment and decree given by the court, yes, a particular ship was sunk, a particular ship has not paid the amount of the plaintiff, that judgment. A ship can be confiscated and arrested under the Admiralty jurisdiction if the salaries are not paid, if your goods are confiscated, if the owner of the ship has not paid you the amount here. This is a very ex parte orders are passed by the High Court under its Admiralty jurisdiction in the matter. So the judgment is binding upon the entire world. The plaintiff or defendant can rely upon it here. So if tomorrow anyone purchases the ship, you may take at the plea, I have a lien first, my lien must be discharged. I have a right to attach the property. The ship is under attachment. Unless and until you clear my amount, and you should not be in a position to purchase it here. That is what here. So it attains a final character. That is what section 4 says. It's a conclusive proof. Then finally it says that or insolvency jurisdiction. So a final judgment and decree passed by the insolvency court. Now, formerly the High Court and district courts there were two acts, Presidency Towns Insolvency Act and Provincial Towns Insolvency Act. Under the Presidency Towns, the Bombay, Calcutta, Madras were exercising these high courts, the insolvency disputes. And whereas the district courts in the district area were exercising jurisdiction under the insolvency. Now we have got IBC presently, where the NCLT has come into play. You all know that here. So all the insolvency dispute, a judgment and decree finally given by the insolvency court. Now it is the DRT, now it is the insolvency. Now the question may arise before the court whether the Debt Recovery Tribunal, NCLT, are courts within the meaning of Evidence Act, whether the judgments given by them can be characterized as conclusive evidence or judgments in rem. That's a disputed question. But I gave one of the Supreme Court judgment. If a particular tribunal or forum has been given a power to record evidence by the statute and has a trapping of a civil court, it's a court within the meaning. Now, under the NCLT Act, you know that here, the NCLT under the IBC has power to record evidence. There's a sections 89, 60, I've seen or gone through that here. They have power to record evidence. Of course, the provisions of CPC may not strictly applicable to them, but they have their own inbuilt scheme of Evidence Act. So at the same time, they have been given power to try the insolvency dispute. So prior to the IBC came into picture, the Bombay High Court was entertaining all insolvency dispute in the city of Mumbai, passing a decree that suppose a decree has been passed against A in a suit filed by B for an amount of 1 lakh. He doesn't want to pay the money. In execution, he said that I don't have money. So I don't have money, that you can, that if the judgment, the plaintiff, the decree holder can move the insolvency court for a declaration that this gentleman is become insolvent. The official assignee takes possession of his entire property. The court receiver is appointed and he takes possession. Then there is a newspaper advertisement, insolvency notice issued. Then if the insolvency notice issued, it amounts to the man will be defamed. So he'll come forward to pay the money. He must be having Benami transaction, Benami properties, a property in the name of third parties. Any person having knowledge, they can provide information to the district court, high court, or insolvency court that these are his properties. The court will take the official assignee is the officer in the high court who is appointed to take possession of such property. He acts like a court officer under Order 40 Rule 1 CPC, a court receiver who is the custodial agent, and he distributes the property, isn't it? So people would like to avoid this ignominy, a defamation of issue. They pay the money off. If they don't pay, ultimately the court will collect the money and distribute to all the creditors in the market. So you all know that here. So a final judgment which has been recorded by the insolvency court is a judgment in rem and not in personam. It is binding upon the entire world and it cannot be challenged. That is what the section 4 says, that you will not be permitted to, unless you have file an appeal against this order in the division bench of the High Court, or you have gone to the Supreme Court under Article 136, or file revision, whatever remedy available to you. If you are not taken, the judgment is final. So then it attains the character of finality and it becomes a conclusive one under section 41. So this is the meaning of the judgments in rem, which are totally distinguishable from judgment in personam. Judgment in personam examples are suits filed for declaration under the Specific Relief Act, for a declaration that A and B are the joint owners, for a declaration that the agreement of license or agreement is valid, subsisting, and defendant is bound and liable to give specific performance and put you into possession. So these are private disputes which are called judgment in personam. Judgment in personams are not covered under section 41. So that means they are not conclusive proof under the provisions of section 4 read with section 41. So only a final during the hearing, when the matter is pending before a matrimonial court, before a probate court, before an insolvency court, admiralty court, you may take out an application for injunction, you may take out application for receiver, you may take out any interlocutory application. The interlocutory order which may be passed by the court is not a final decree. You know that here. It is not a final decree and it is not conclusive. But it is only a final judgment mean after adducing evidence. The court establishes the substantive rights of the parties, whether A and B were duly married, whether A has succeeded in proving that the marriage is a void ab initio, the court grants a decree, isn't it? Then in the insolvency, whether A has committed the act of insolvency under the provisions of Insolvency Act, IBC Court, then the final order which has been passed after giving opportunity, after leading evidence, after satisfying the principles of audi alteram partem, then it becomes a decree. Similarly, in the case in regard to probate, the probate court will not give you a probate just because you lodge a will. The court is issuing notices to all the legal heirs and legal representatives. You have to fill up in the form, these are the heirs and legal representatives. The court will issue notice upon them. They might file a caveat. The moment the caveat is filed and the probate proceedings become contested suit where evidence is recorded like a civil suit, under the provisions of Section 9 of the Code of Civil Procedure. There are contentious, disputed facts come into play. Ultimately, when the court, after appreciating the evidence on record, then passes a judgment and decree, then issues a probate, then that probate becomes a final order, which is a conclusive judgment under Section 4, read with Section 41. Okay? So these judgments, here, once it is produced by a party in any proceeding, it is not open to challenge it normally, unless the other party takes up the plea that year. Now the requirement, you should know that here, it must be passed by a court which is competent. Please note that here, a final judgment and decree of a competent court, underline the word, and a competent court must be having jurisdiction. Now you know that here, whether a decree passed by a foreign court, for example, a suit, husband and wife, Indian, they go to America and settle down. Many of the Indians from several states settle down in various parts of USA. There are lots of matrimonial disputes which are governed under they are known as a conflict of laws. You know that the private international law, that's a Hague Convention of 1970 they dealt into, because our Hindu Marriage Act doesn't deal with it, nor any of the litigation. So you should know the Hague Convention that. Now, when the husband or wife obtains a decree for a foreign court, namely from USA or Canada, whether that judgment and decree, so the parties are Hindus, they were initially living in Bombay or maybe some other states of India, they work in America. So that there is a discord in matrimonial relationship, as a result whereof the husband or wife filing a petition for divorce. There are lots of such matters filed in US court and Canadian court and British court here. Now, sometime as a result of this strained relationship, the wife may not be staying there, she comes back to India. And when she doesn't dispute, when she doesn't contest the proceeding, or merely she writes a letter to the courts in foreign country, I am not submitting to the jurisdiction of your lordship's country and I am disputing all the contention. But she doesn't file written statement and she doesn't participate in trial. And what does the court in America do? They pass a decree, because a notice was given to the defendant in the matter to appear before the court of law. It's a matrimonial litigation, and I will give you 2-3 examples of the judgments here. And the court entertains the dispute and passes it here. Of course, the Indian gentleman, the husband who has filed the case, he has to mention that myself and my wife were married under the Hindu Marriage Act. So normally your marriage was solemnized in a temple, maybe in a court in India under the provisions of a Hindu Marriage Act. Hindu Marriage Act normally even divorce is to be taken, and the provisions of Section 19 of the Hindu Marriage Act tells you a divorce can be applied for by the couple, by the couple, one of them residing at the place where the marriage took place, or where they are residents in a particular area. So the husband may take up the plea that I am staying in a state of Louisiana. My wife also came along with me and she stayed for some time, and I am a resident of this state here. So I come within the mischief of the provisions of Section 19. I have a right to file. Then she walks away and she goes back to India, settle down, stays with the parents. Now she comes, then he realizes the husband obtains a decree in American court and remarries. He informs. So when he remarries, what does the wife do? In some of the cases, they start proceedings under bigamy under Section 498 of the Indian Penal Code. She will take up the plea that the decree of divorce which has been passed by the American court is not binding upon me, because it is not a competent court. It is not a court. It is not a competent court, because under the Section 19 of the Hindu Marriage Act, the law says that the party must be resident and the law of the land must be followed. So the substantive law of India was Hindu Succession Act. Naturally, the American court will hardly look into that. American court may say that They have gone on the representation that yes, the husband was staying in the state of Louisiana or Connecticut, wherever it is. Yes, the court has a jurisdiction, entertain and passes the decree. But technically, whether that court is having jurisdiction. Now, under the Hindu Marriage Act, which court can pass a decree? Only a district court or a family court now under section of 7 of the Family Court Act. You know that. In cities like Bombay, Calcutta, Madras, wherever the family court is set up, the family court can pass the decree. It has exclusive jurisdiction. Otherwise, the decree can be passed by the district courts. So, whether the court in America which passed a decree is a district court? No, the answer. So, one such judgment came up for consideration. I think I gave it to you in your yesterday's WhatsApp chat. That is Narasimha Rao versus Y. Narasimha Rao versus Y. Venkata Lakshmi. This is reported in 1991 Supreme Court. It's a very interesting judgment. I will just give you the facts which that arose in the case. Y. Narasimha Rao versus Y. Venkata Lakshmi Rao. Please, can you take it out, Ashish? Anybody else? Gitanshu?
Yes, sir. It's on the screen, sir.
In the screen. Now,
Yes, sir.
it's a very, very interesting facts of the case and very disturbing, very unfortunate.
Sir, quick question, sir, before we go there, sir.
Yeah.
So, what happens if both parties are Hindus, but one is an American Hindu and one is an Indian Hindu, and the marriage was solemnized in the US? Then, which is the competent court of jurisdiction?
If the marriage was, but under which law the marriage took place? As in, under the they took pheras liye hain kya? 7 pheras as Hindus.
Yes.
That is, if they had taken 7 pheras, yes, Hindu Marriage Act will come into play.
Okay, but the Indian Hindu Marriage Act will come into play, sir?
Yes, our Indian, our Hindu Marriage Act, that is, you know, the provisions of the Hindu Marriage Act of 1955. Okay? And
Okay,
section 19 deals with jurisdiction and procedure. Every petition under the Act shall be presented to the district court. Please know, open section 19. Should be filed to district court.
Yes, sir.
Got it? Yeah. Now, let us say, in the light of this, we examine the judgment given by the Supreme Court of this Indian couple, that is Y. Narasimha Rao versus Y. Venkata Lakshmi. That is a judgment given 9 July 1991, very beautifully written by Justice P.B. Savan, who unfortunately died recently in Pune, one of the senior most judge, very respected judge, along with Justice Ranganath Mishra, who was the uncle of Justice Deepak Mishra. Justice Ranganath Mishra also went to the UN court, like our Justice Bandari Sahab. Let us see the example. In this matter, see that here. Now, the husband and wife, the marriage was solemnized in Tirupati. That is on 27 February 1975. If you just see that facts are given. Then they were separated in July 1978. 3 साल के अंदर separation हो गया. Then the appellant, that is the husband, he filed a petition for dissolution of marriage, first in a circuit court of St. Louis County, Missouri, USA. I think just Dr. Pradeep Mehta will be able to tell us what is Missouri, USA. Then, after filing the suit, he sent the papers to the respondent wife. She sent her reply under protest. And in the protest, she said that here, that she is not submitting to the decree of the court, jurisdiction of the court. Now, the circuit court passed a decree for dissolution of marriage on the 9th of February 1980. In the absence, that is, the ex parte decree was passed against her as she did not participate in the trial. Okay, that is the fact here. Now, then what happened? In November 81, this gentleman, the Narasimha Rao, got married to the second appellant. He again remarried. As a result of the remarriage, the wife files criminal proceedings for offense of bigamy. You know that the offense of bigamy is coming under Huh? It is punishable for 7 years. All of you know that here. IPC में पढ़ चुके हैं आपने.
Yes, sir.
Bigamy
Yes, sir.
is a very serious offense. Punishable for 7 years. She filed a petition. She filed a criminal complaint. Then what happened? This gentleman, Mr. Narasimha Rao, she filed in Tirupati somewhere in India. Then he comes to Tirupati. She files an application for discharge. Now, under the CRPC, you know that here there is a provision for discharge. पढ़ चुके हैं आपने, isn't it? On the ground that she is not my legally married wife. I have obtained a divorce from the Missouri court, USA. On the production of the certified copy of the judgment of the Missouri court, the magistrate discharged the appellant. समझे ना? The order of discharge was passed, isn't it? You know, you have just learned the CRPC when the magistrate can pass an order of discharge. पढ़े ना आपने? Anybody can quickly point out the provision? Section 245. When accused shall be discharged. Trial in warrant cases. Okay? That is not going to it now. Yes. When discharged, then the matter went to the High Court. She carried the matter to the High Court. The High Court of Andhra Pradesh, they set aside the order of the magistrate holding that photocopy of the judgment of Missouri court, USA, is not admissible in evidence to prove the dissolution of marriage. Now, if you go into section 41, it's a conclusive proof. Under section 41 of the Indian Evidence Act, it's a final decree of divorce is a conclusive proof. Now, here the High Court says that what was brought is a copy of the order from the US court, which is not authenticated from the Indian embassy. I will come into it. Because a certified copy, when you apply from the US court, you just straight away cannot bring it here. It must be authenticated by the Indian embassy in USA. That provision, you know, we read yesterday at section 86. I will come to it. Before I once again read section 86, then I will tell you. Then the court took up the view that here, now, when the High Court took up this plea, then the matter went to Supreme Court. Now, before the Supreme Court, there were very important, contentious, disputed legal points with regard to the validity of the order passed by the Missouri court. Because the Supreme Court examined that here, the decree of divorce was obtained by the husband by making a fraudulent representation that he was a resident of the state of Missouri for 90 days, which is a condition precedent. Unless you reside for 90 days in that country, you cannot be a resident. Then the court said that he was he did not reside there on that ground. Then the second contention which arose before the court was that here, under the Hindu Marriage Act, only a district court can pass a decree for dissolution of marriage under section 19, which we read right now. As such, the American court, the US court, Missouri court, is not a district court. It does not have jurisdiction to entertain the petition for divorce. Okay? Now, it is now relevant to read at this stage. Now, they invoke the provisions of section 13 of the Code of Civil Procedure, where the foreign judgment is not conclusive. In the last session, we learned the Code of Civil Procedure. Now, I would like to again show that. Now, section 41 of the Evidence Act tells you a judgment and decree pass, a final decree by the matrimonial court is a conclusive one. Now, let us see what section 13 CPC says. Please open section 13. Section 13 says, when foreign judgment not conclusive, see that section 41 of the Evidence Act should be read in conjunction with section 13 CPC. Now it says, a foreign judgment should be conclusive as to any matter thereby directly adjudicated upon between the same parties and one of them claim litigating on the same title, except when it has not been pronounced by a court of competent jurisdiction. So, by no stretch of imagination, the Missouri Court of USA is a district court. And the language of section 19 of the Hindu Marriage Act says that here it must be a competent district court. Why did they? Had it been a district court of that particular state, apart. But they went to, this is a circuit court. A circuit court is not a district court. So it is not a competent court of jurisdiction, number one. Number two, where it has not been given on the merits of the case. So the wife who was in Tirupati, she did not go there. She was not compelled to come and give evidence. Probably there was no record to show that any warrants or summons were issued, or the request could have been made to record her evidence and videography, which was permissible in USA, being a very advanced country, which was not done here. So, it was the judgment and decree was passed not on the merits of the case. So, without taking a written statement and record, without asking her to come, she has not deposed. She did not participate. She has shown her unwillingness to participate, saying that I am not submitting to the jurisdiction of the US court. Number three, where it appears on the proceeding to be found on an incorrect view of the international law or refusal to recognize the law of India in cases in which the law is built. Here, the American court of Missouri has incorrectly applied the US law. The US law is not applicable to the Hindu couple who married under the Hindu Marriage Act of 1955. You had to invoke only the provisions of section 19 of the Hindu Marriage Act, namely come to district court and file a petition. And number two requirement, one of the parties must be resident, and it did not reside there. So the conditions are not satisfied. Thirdly, she never had the opportunity to fight the case on merit of the case. And the American court has not correctly applied the international law and refused to recognize the law of India. So the provisions of Hindu Marriage Act 1955 are not dealt under. Had the learned judge of the US court taken cognizance of the provisions of section 19, he would not have passed a decree. That is what the Hague Convention of 1970 says that here. You also must have learned in your second year or maybe in third year, the private international law, the conflict of laws. In India, the conflict of laws coming into various provisions of the matrimonial law, Divorce Act, the Indian Contract Act, Succession Act, and the various acts. There is no particular book as such because you have to rely upon the international convention in that regard. So, taking into consideration section 13, the Supreme Court said it cannot be called a decree of the court. Then, fourth item, where the proceedings in the judgment were obtained are opposed to natural justice. So, the principles of odi alteram partem are not complied with. She was not given a fair opportunity to fight the battle for divorce in the US court. So, the decree is invalid. Then again, where it has been obtained by fraud. Now, a contention was raised before the Supreme Court that a matrimonial judgment, being a final order and decree, is a judgment in rem under section 41 to be read with along section 4 of the Indian Evidence Act, and it cannot be challenged. That has not been found in acceptance by the Supreme Court, not only in this present case and also an earlier judgment of Justice Chandrachud judgment. You may see that here. Sorry, I failed to inform you yesterday. That is called Satya versus Teja Singh. This is a judgment reported in AIR 1975, page number 105. A very beautiful judgment drafted by the then Chief Justice Chandrachud, the father of present our Dr. President Chandrachud. It's a bench of Justice Chandrachud and Justice Khanna's judgment. It's a very what do you call it here? Scholarly judgment, wherein the Supreme Court clearly says that here the provisions of the judgment in rem can also be challenged, invoking the provisions of Section 44 of the Indian Evidence Act. So, because we learned that here, just I would like to draw your attention to immediately the provisions of Section 44. If you kindly see, when fraud is played, that is what Section 13 says. When fraud is detected, how fraud is detected? You please kindly see Section 44 of the Indian Evidence Act. Fraud or collusion in obtaining judgment or incompetency of a court may be proved. Any party to a suit or other proceedings may show that any judgment and order decree which is relevant under Section 40, 41, 42 and which has been proved by the adverse party was delivered by a court not competent to deliver it or was obtained by fraud or collusion. So, this is an exception to Section 4 and 41. Section 44 is an exception. That means wherever there is a fraud, suppose husband and wife, the husband say that the decree has been passed for dissolution of a marriage. The wife will take up the plea, I never went to court. It is not my signature. That means the husband has taken to the family court. He will say that the decree by consent. So, under the Indian legal system, a consent decree is valid, isn't it? And the wife tomorrow says, no, I did not, I was not a party at all, I did not go, and this is not my signature. My husband has played a fraud upon the court. He wanted to marry this lady and he has played a fraud. My marriage is not at all divorce. I never went to court of law. I never filed any consent term. If you show that here, then the decree is void. So, in the American court, in Narasimha Rao's case versus Venkatra's case, the Supreme Court took the view that here, having filed the petition before the Missouri court with a representation that you are a resident for 90 days, you made a fraudulent representation. So, when you made a fraudulent representation and obtain a decree, not binding. So, Section 13 of the CPC I read out to you right now, how the decree not binding. Then where it sustained claim found on a breach of the law in force in India. See that here? Section 13 ka last limb, that is clause F, says where it sustains claim found on a breach of law in force in India. Now, another interesting point before the judgment of Justice Chandrachud, that is in Tejas, that is I'm sorry, party's name is Tejas case. I'm just giving you. Yeah, that is a Satya versus Tejas Singh. One of the contention raised was that here, the husband who went to America obtained a decree. The wife was in Punjab. She had filed a petition for maintenance under Section 125 of the CRPC. So, the husband took up the plea that I am not liable to pay maintenance because she is not my wife. I have taken a decree from the American court. Now, in that context, the counsel argued that here, the judgment which has been passed by the American is a matrimonial court, and whereas the proceedings filed by the court are under the CRPC, and the proceedings judgment cannot be invoked for the purposes of criminal matter. Now, dealing with such a contention, what does the Supreme Court says? When you see the paragraph relevant, I think page numbers are not there. Can you see? Section 13A of the Code of Civil Procedure makes a foreign judgment conclusive as to matter thereby directly adjudicating where it has not been pronounced by a court of competent court. Learned counsel for the respondent urged that this provision occurring in the CPC cannot govern criminal proceedings. Can you just open this, any one of you, in the judgment, in this paragraph? See that? Learned counsel for the respondent. This is somewhere about the second last paragraph of the judgment. Please see that. Are you able to lay your hand? Can you? Gitanshu, can you lean? Gitanshu or Ashish?
Yes, sir.
Yeah, just see, Learned counsel for the respondent urged that this provision occurring in CPC, that is section 13, cannot govern criminal proceeding, and therefore the want of jurisdiction in the Nevada court to pass a decree of divorce can be of no answer to an application for maintenance under section 488 CRPC. This is the old 48 is now section 125. Now, this argument is misconceived. That means the Supreme Court said that the order which is passed in a civil court can also be utilized in criminal court. That is what the meaning here. This argument is misconceived. The judgment of the Nevada court was rendered in a civil proceeding, and therefore its validity in India may be determined in terms of section 13. It is besides the point that the validity of the judgment is a question in criminal court and not in a civil court. If the judgment falls under any of the clauses A to E of section 13, it will cease to be conclusive as to any of the matter thereby adjudicated upon. The judgment will then be open to collateral attack on the grounds mentioned in the 5 clauses in section 13. See that here, number 1. Then the court took up the plea, Supreme Court. It's a fraudulent order which I obtained from the American court. Now the next paragraph, you see that here. Under section 13E CPC, the foreign judgment is open to challenge where it has been obtained by fraud. Fraud as to merits of the respondent case may be ignored, and his allegation that the wife has been living separately apart from them and 3 consecutive years without cohabitation, and there is no possibility of reconciliation, may be assumed to be true. But fraud as to jurisdiction of the Nevada court is via consideration in the recognition of a decree passed by the court. It is therefore relevant that respondent successfully invoke the jurisdiction of Nevada court by lying to the jurisdictional fact. In so-and-so cases, they relied upon the other English cases, which is not relevant for discussion. So this is what I want to say, that here, when a person, a husband or wife, makes a fraudulent representation as regard to the jurisdiction of the court, the judgment is fraudulent. Now, as regard the whether the judgment and decree passed in a civil court or a criminal court is binding or not, can be seen also from the language of section 44, which says that here, again you pay attention, 44, a party to a suit or other proceeding, underline this word, a party to a suit other proceeding means it also includes criminal proceeding, may show that any judgment and order or decree under 41, 42 has been proved adverse so and so is obtained by fraud. So, the wife can show before the Indian court. Now, in the present case of the Rao's case, that is Narasimha Rao versus Venkatalakshmi's case, she has successfully shown before the Tirupati court, where she has filed a petition for a petition on the ground of that the husband has committed adultery, matrimonial dispute, by showing that here the American judgment is not binding upon the criminal court here, because that was not a certified copy and it is not a court which has passed the decree in the matter. So the judgment of Narasimha must be read along with the judgment of the Supreme Court in the case of in the case which I write right now, that is a Satya versus Tejas Singh, reported in the 1975. Supreme Court, page number 105, and SCR ka page number 97. So, a very important two judgment. Please note that here, when foreign decree which has been passed is not acceptable in India. Examples here. So, because section 41 tells you here that the judgments are conclusive or no. Then finally, see in the Narasimha Rao's case, I would like to draw your attention about the inferences drawn by the court as regard the document. Now, the High Court took up the plea that here the certified copy which has been brought from the American court, Xerox copy, is not a public document, cannot take into consideration. Now, the Supreme Court took up the view that under section 74(1), subclause 3 of the Evidence Act, just open section 74, subclause 3(1), it is a public document. Section 74 खोल दीजिए आप. Yeah, section 74 define public document. 74 में subclause 1, item number 3. See, public officer document is a public document of a public officer, legislation, or any part of the Indian or Commonwealth or of a foreign country. Underline this word. Yeah? So, foreign country ka judgment comes within the meaning of section 74, point out. Then again section 76, 77, certified copies of the document may be brought in proof. See kindly section 76. Certified copies are public document, how they are proved. So, when a judgment of a foreign court, how it is proved, I would like to show it here. So, you have to invoke after 74 ke baad 76. Number 1, every public officer having the custody of a public document, which any person has a right to inspect, shall give that person on demand a copy on payment of the legal fees together with the certified written on the foot of the copy, that is a true copy or part thereof, as the case may be, and such certificate shall be dated, subscribed by such officer with his name, and is certified, shall be sealed when such officer is authorized by law to make use of, and the copy certified shall be called certified copies. So, a certified copy becomes a certified copy on a public document, provided the officer responsible signs it, seals it, and delivers it to you. Then, after 76 is applied, then 77 has to be invoked to. Proof means how the document can become proof public document, because you are not going to ask the Election Commission of India to come and depose before the court of law if you are relying upon election record. If you are relying upon a foreign judgment of an American court, you cannot tell the foreign judge who passed the order should come and give judgment. You are not required. If a passport is issued by the President of India, you cannot compel the President of India come and give evidence because it is a fraudulent document. No. Section 77 tells you what kind of a proof is required. See, proof of document by production of a certified copy. Such certified copies may be produced in proof of the content of public document or parts of public document of which they are purported to be copies. So, you are allowed to produce even the copies. Suppose the judgment of the Supreme Court, you can rely upon anywhere in the world, provided that judgment is signed by the Sheriffdar of the court, the officer. Yes, this is the minutes of the order, copy, sign, I am signing it, certified copy. So, whenever you see the orders of the Supreme Court, High Court in Bombay, any court, when you apply for certified copy, likha hoga, copy applied on so and so date, judgment copy signed on so and so date, delivered on so and so date, copy collected on so and so date, compare on so and so date. ये सब क्यों लिख रहे हैं? With a view to see that here the copy is, the judgment has been taken directly from the original copy, to show that it's a public document, number 1, and all the entries which are correct here. So section 74(1)(3) के बाद 76 will come into play, then 77 will come. And finally, since it's a foreign judgment of the American court, you cannot straightaway take it on record by bringing to the office only, unless this document is required to be authenticated by the Indian office. Indian office, that I'll point out the provision. Please see that section 86 check करो आप उसके लिए. So when does the court draw presumption? We told you that the court may draw the presumption that a certified copy of a judicial document is correct. Now, in the cases here beforehand, in the two cases which we are discussing, that Narasimha Rao's case and the judgment of the Supreme Court, in the case of in the earlier case of Satya versus Teja Singh, when does the certified copy obtained from the American court or a British court, Canadian court is certified copy? You have to not only rely upon section 41 of the Evidence Act, 43, section 4, but also 74, 76, 77, and lastly, section 86, if you are relying the judgment in any other court. Now, please pay attention to 86, what I am saying. The court may presume that any document purported to be certified copy of the judicial order of any country not forming part of India. That means a copy of the order of judicial order of foreign country, USA, UK, Canada, all countries except India, forming India, India or His Majesty Dominion is genuine, is certified by the representative of the central government. So it must be certified. After, if you are a plaintiff in America who had obtained a decree of divorce from Connecticut court or New York court, please go to the Indian embassy first. The Indian representative must sign that document. You must show the original to him. Yes, he will ask for you to show your passport detail, your American details, that you are citizen or not, so and so. उसके बाद वो सर्टिफिकेट देंगे आपको. See, the central government of such country, to the manner commonly in use for the certification. It is only when the Indian embassy in USA gives a certificate. It is not just a certificate from the US court or the Saristadar or judicial officer of the American court is sufficient, but you must go to the Indian embassy and take signature if you want to rely upon this order in Indian court where other proceedings are filed by your wife, husband, or any other judicial proceeding. Otherwise, the copy will not be taken on record. So the court will presume that the document is correct, provided it has been certified to be correct not only by the court which passed the decree, certified by the representative of the central government, Indian government. Please note that. This is what you have to make. That is clearly given in section 81. So the provisions of section 41 must be read in conjunction with section 13 of the CPC, 14 CPC, and the provisions of section 74, 76, 77, and 86 of the Indian Evidence Act. So how these facts are interconnected. So as a result whereof, then the Supreme Court, what did the Supreme Court say? Ultimately, in Narasimha Rao's case, it set aside the order of the High Court, which said that a copy merely cannot be taken because the High Court had not dealt under the aspect of the provisions of section 86 in the requirement. Then ultimately the order, see that here, paragraph number 16 में क्या order पास गया. While therefore holding that the document is not admissible in evidence for want of certificate under section 86. Please see that here. Now, judgment of Narasimha versus Venkata, paragraph number 16. If you open last, this is the concluding paragraph. What does the Supreme Court say? That while therefore holding that document is not admissible in evidence for want of certificate under section 86 of the Act, not because it is a photocopy of the original as held by the High Court, we uphold the order of the High Court also on the more substantial larger ground as stated in paragraph 14 above. Accordingly, we dismiss the appeal and direct the learned magistrate to proceed with the matter pending before him according to law expeditiously as possible, preferably within 4 months. So the magistrate who is trying criminal proceedings had discharged the husband in Tirupati, holding that here husband has produced certified copy of the American Court of Divorce, which the High Court says a copy of the divorce is not sufficient, without going into the provisions of other provisions of section 14 of the CPC, 13 CPC, and section 77 of the Indian Evidence Act, 76, 77, and 86. The Supreme Court, this is a very landmark judgment. This judgment of the Supreme Court in Narasimha Rao's case, and Satya, it should be read along with Satya versus Teja Singh. 74, in the year is 1974, and this is Venkat Rao's case is 1991. This will tell you what is a conflict of law, what is an international law, and how when dispute arises between Indian couple in a foreign country, when decree is passed, whether such decree is binding or not, what is the validity, relevancy क्या है उसकी Indian Evidence Act में. These two judgments will clearly tell you. Please bear in mind and study them. Go home tomorrow, whenever you find time, read them 2-3 times, this judgment very well. How much time we have spent?
Sir, 7:45, sir. So we spent about an hour 15 minutes.
Acha, we'll take a break for 10 minutes. Okay?
Okay, sir.
We'll take a break for 5-10 minutes, then we'll come back. We have a cup of tea and come. Okay?
Okay, sir.
Okay. I want to congratulate the student who scored 90 marks here in CPC and 88 marks in CRPC. Is the student present here in the lecture?
No,
Our GLC student, I just got the message. Anyway, congratulations. So we'll meet up after 10 minutes. Okay?